Kele.
Hello, guy.
Ki kupa ukwale mic wa haune. Kuna li noise ya tanki.
Ishabo.
Ya kukupa ikwale. Thanks.
Kikwale.
Unmute.
Oh, give me okay.
Thank you, Dan.
Give me till.
No, ntobu wa ikwale no kwezi ya.
Okay.
Thanks.
Vale.
Start a copy and hash to confirm the welcome tone or remote.
Good morning.
Oh, good morning, everyone in the meeting. Good morning, honorable members. Good morning to the officials from the Department of Environment,
Good morning, Chair.
Environment, Fisheries and Fisheries. Good morning to the Department of National Forestry. Good morning to the officials from the Gauteng Environment or GDAD Department.
Good morning, Chair.
Good morning to the stakeholders that is with us today. May I check how many members are in the meeting?
Morning, Chair. Member Silesia.
Member Silias. Members, who else is here?
Good morning, Glenn Malherbe, stakeholder, Chemical and Allied Industries Association.
Thank you very much, sir. I'm just checking firstly members of the portfolio committee who are here.
Ngube,
Member Mncube, thank you very much. So I have member Mncube and member Silias. Thank you very much. I think we'll start with the public hearing. Let me welcome everybody in today's session. My name is Lindiwe Lasindwa. I am the chairperson responsible for oversight on the Department of Economic Development, Environment, Agriculture and Rural Development Portfolio Committee. Today we are meeting here because we want to give our stakeholders an opportunity, firstly, to know that there are two bills which are due for being amended, and we want to give them this information. Two is for the stakeholders to make submissions if they have on these bills, because these bills will appear before the NCOP, which is the National Council of Provinces. Today's session is our second session. Because of the lockdown regulations, we had to divide our session into two, and also taking into consideration that we are using this platform, which only allows a particular number of participants per meeting. So last week, we had a session which was very successful. About 60 stakeholders attended the meeting. We are awaiting their submission, because the date for the submission, the closing date is the 5th of October. I was informed that today we only were able, or only 10 stakeholders confirmed that they will attend today's session. But I will get an update, honorable members. We also agreed yesterday with the support staff that we will continue with this platform because it is a platform for stakeholders. With those words then, honorable members of the committee, we have received a presentation from both the department, national and the provincial one. So today's session is to give stakeholders to make submissions. Ngithathe lethuba ngisho ukuthi kulabo abakhona emhlanganweni namuhla namukelekile nina nonke. Siqale nalomhlangano isigaba sethu sokuqala besingomgqibelo odlulile. So siyaqhubeka ke namuhla nalomhlangano kwisigaba sesibini. Inhloso yalomhlangano ukunikeza amalungu omphakathi nezinhlangano ezikhona eGauteng ithuba lokuthi baphawule kulomthetho ohlongozwayo. So nina nonke enikhona la namuhla namukelekile. Futhi nivumelekile ukusebenzisa ulwimi lasekhaya. Uma ufuna ukusebenzisa isiZulu, uma ufuna ukusebenzisa isiSuthu, uma ufuna ukusebenzisa isiTsonga. Ngoba si-committee laseGauteng eSouth Africa. Ngaloko ke abantu base-South Africa bavumelekile ukusebenzisa amalwimi wasemakhaya. Ekakhulu kule nyanga njengoba sigubha amagugu kuyinyanga phecelezi esithi inyanga ye-heritage. Siyathanda ke ukuthi abantu baziqhayise okanye bazigabise ngoba ubona. Ngaloko ke sizoqhubeka nomhlangano. Engizocela nje manje ngizocela amalungu wekomiti ukuthi bazazise. Ngizocela nje bavule ivideo ilungu lekomiti lizazise ukuthi lingubani. I'm going to take this opportunity to request honorable members of the portfolio committee to introduce themselves. Please, honorable members, switch on your video and you introduce yourself for the stakeholders to see you. May I start with member Silias?
Good morning, everybody. I'm Ina Salia. I'm a member of the committee.
Yes. Very much, member Silias. Member Mncube?
good morning, Honorable Chairperson and stakeholders. My name is Honorable Pinky Mncube. I'm a member of this committee. Thank you.
Other members who have logged in. Members of the committee. Okay, thank you very much, Honorable Mncube and Member Silias. Members, I have received an apology from Member Hassan, but she said she'll join the session late. She could not start with us now due to other commitments. That is the only apology that I have with me. May I check with Sisnozi or Lebu, do we have any other apologies for today's session? Sisnozi, no Lebu, akhona ama apology enotholile.
Good morning, Chairperson. I have not received any apologies. Thank you.
Okay, thank you very much, honorable members.
Kosilwane. Kosilwane.
Who's talking? Okay, honorable members, officials from both departments and the stakeholders who are here, we are going to start with the session. Today, we are going to deal with 2 bills and will allow stakeholders to make their comments. But Lebu, for the purpose of today's meeting, can we allow stakeholders also to do like members did? All those who are here to switch on their video, introduce themselves. If they're coming from an organization, they tell us what is their organization and from which region are they coming from. Ngithatha lethuba ke nginikezela wonke umuntu okhona la emhlanganweni ukuthi azazise. Ngizocela nje ukuthi uvulele indlela leyokucophela sibize ngevideo sizokwazi ukubona ubuso bakho bese uyazazisa emhlanganweni nokuthi uphuma kweyiphi inhlangano wena nokuthi uphuma kwesiphi indawo la eprovincini iregion mhlambe eJoburg eKuruleni or eSidibeng. Let me take this opportunity then to allow stakeholders to introduce themselves. Anyone who wishes to start can start.
Thank you, Honorable Lindiwe. My name is Glenn Malherber. I am Head of Policy Analysis at the Chemical and Allied Industries Association. And thank you for this opportunity.
Thank you very much, Sam. The next one, please. Omunye already kuzazisa.
Morning.
Morning.
My name is Karin Kwanyana from Public Service Commission.
Thank you very much, Ma'am Kwanyana. Next one, please. Re kopa batho ba le teng ka mo meeting-ing ba ititsebise hore bona ke bo mang ba tswa ko kopanong e feng le gore ba tswa ko region-eng e feng ka mo Gauteng. I have only noted 2 stakeholders and I was informed that 10 have confirmed for today's session.
Good morning.
Can I get an update? Yes, you can start. Unmute yourself.
Thank you. It's Priscilla Stichling from the NSPCA. We're an animal welfare organization and we operate nationally.
Thank you very much, Priscilla.
Thank you.
Next one, please. Next stakeholder. Trying to get a better view, members. Without shade, so it's very dark in my. Yes, Baba, can you speak? Apola, can you speak? Unmute yourself. Can you continue with others who are ready? I only listed 5 stakeholders, honorable members. Or should we continue? Others will join us, or as it continues, they are much, much better. Yeah, this is much better. Those stakeholders who have joined us, they will introduce themselves during the session. This opportunity and welcome officials from the National Department and the Provincial Department. Without wasting time, let us start with the presentation. National Environment, Fisheries, their presentation. My appeal is that let us read word by word the document, if possible. Let us give an executive document, the clause which are going to be amended or which are subject to be amended. Stakeholders will receive the whole document, or some of them have received the document. Who's going to present the NEMLA bill?
Thank you, Chair, Honourable Chair and Honourable Members and stakeholders. I'm Linda Garlip. I am at the moment the Acting Deputy Director General for Regulatory Compliance and Sector Monitoring. And with me, I'm just going to switch on my video that you can see me just for a moment.
Let me also switch mine off.
And thereafter, I'm going to switch it off. I have a whole team with me today that will assist with the answering of the questions, and I'm going to quickly introduce them. I have Dr. Dee Fisher. She is the Chief Director Environmental Impact Management, Advocate Nicolette Fink, and she is from Law Reform, Ms. Lisa Redlinghuis. She's the Environmental Control Officer. Then Ms. Magda Ms. Magda Boshoff, and she is the Deputy Director TOPS and Policy Development. Mr. Anban Pillay, he is a Deputy or Director Waste Policy and Information Management. I have Mr. Vincent Kulu, he is from Equality, and Mr. Tami Zwane, he is also from Law Reform, as well as Mr. Nayo Nikotsu, also from Law Reform, and the person that organized this all from our side is Ms. Buyiswa Nedibongo. And without further wasting of time, I'm going to start the presentation. Can everybody see the presentation?
Not yet, ma'am.
Not yet.
Maybe there's just okay, just give me a moment. Can everybody now see the presentation?
Not yet, ma'am.
Is it on now?
On my side, not yet.
Okay. I'm just quickly switching over to another, because it's so slow. Let me just quickly see why it does that.
Is there no one who can assist you by flighting this presentation? Lebu, can't we assist by flighting the presentation?
Just give me a moment. I am.
Lebu, is there, you can't assist? Linda, are you willing?
I think. Okay, now it looks like can Jay, can we start with the forestry presentation while I log out?
I didn't get that. It was not clear. What were you saying? I think the slides are there, but if you can zoom in, zoom on it. I can see it now.
Hi, Chair. It's level. I've just zoomed this one. I've just beamed this one. I don't know if officials want me to use this one or they made amendments to the one that they're going to make presentations on.
Linda, can you speak to that? I see this one.
Chairperson, I have a connection problem. I will just quickly get out of this meeting. Can you start with the forestry presentation, please?
Chair?
Can't you work on this one, which was presented to the portfolio committee on the 9th?
Chairperson, I have a problem that I hear echo.
Your audio is very bad. There is also an echo there. I can't hear what you are saying.
Chairperson?
Yes, ma'am.
It's Pumeza Nodata speaking. Linda is requesting that she logs out and then so that she can try and sort out the audio and the technological issues that she's experiencing right now. And she's requesting that maybe we can start with the forestry amendment bill in the meantime while she's sorting herself out, if that is acceptable to the chairperson and the members.
Is that presentation ready? I don't have any problem with either. If you are ready with the second presentation, I think we can do that one.
Okay. Shumani, are you able to flight it to project it?
Yes,
okay. Can you also ask those who are not presenting, or if you are not speaking, please make sure that your mic is not on, because we have a background that is disturbing the meeting. If you are then going to speak, then you can unmute your mic and speak. We can start if we're ready with the next presentation.
Okay, good morning, Chairperson, honorable members, members of the public and colleagues from the department. My name is Shumani Zivani from the Department of Environment, Forestry and Fisheries, Deputy Director under the Directorate of Forest Regulation and Support. Are you able to see my presentation now?
Not yet, ma'am.
Okay.
Yes, it's there now.
It's there. Okay, thank you, Chairperson. My presentation outline will cover the following aspects: purpose, objective of the bill, process that has been followed thus far, the National Forest Amendment Bill clause by clause, and the implication of this bill to the communities. As you have already indicated, the purpose of the presentation is to brief the public on the National Forest Amendment Bill, that is B11 of 2016, which seeks to amend the National Forest Act of 1998, Act 84 of 1998. The purpose of this act is to promote sustainable management and development of forests and provide for the protection of certain forests and trees. This act is also called a balancing act because it balances between use and the protection in order to ensure the sustainable forest management of forest. This act authorizes, there are various mechanisms that are provided for in this act that are aiming to authorize consumptive use. Will the act make provision of authorizing consumptive use through the following mechanism: access in terms of Section 19 of the Principal Act. In terms of this section, in terms of Section 19, everyone has a reasonable access to state forests for the purpose of recreational, educational, cultural, or spiritual fulfillment. And also the Act make provision for authorizing consumptive use through licenses that are issued in terms of Section 7, 15, and 23. Section 7 deals with the natural forest. Section 15 deals with protected trees. and 23 deals with activities in a state forest. Another mechanism is exemption.
Hi, Sisi, please unmute yourself. Shumani?
I think something went wrong here.
We are trying to call her as well. Apologies,
Oh.
Chairperson. Calling her from the office to see if she can unmute herself.
Okay, yeah. Okay, thank you. Oh, my apology for that. I was just flowing. I couldn't see that I'm unmute. Thank you. Can I start from the beginning?
I think you can start from this slide where you are, Shumani.
Oh, okay. The objective of this bill are to provide for clear definitions, for example, natural forest and woodlands, and to provide for public trusteeship of the nation forestry resources, increase the promotion and enforcement of sustainable forest management, increase the measures provided for in the Act to control and remedy deforestation, and to provide for appeal against decision taken under delegated powers and duties, reinforce offenses and penalties, and also to promote equity by inclusion of youth and women in the National Forest Advisory Council, that is the NFA. The department has thus far followed all the legislative process for amending the Act. For example, we have conducted several consultations with the public and interested and affected stakeholders. The bill was then published in the Government Gazette for public comments and then tabled in Parliament for further processing. The bill was also tabled at the National Assembly for their consideration, and then to the NCOP, since in terms of the tagging, it's a 76 bill, meaning that there is a bill that's affecting the province for their consideration. Hence, we are here today conducting this public hearing. I will then go to clause by clause. The bill was also tabled at the National Assembly for their consideration, and then to the NCOP. Okay. I will then go through clause by clause analysis of this bill. The bill intended to broaden the definition of a natural forest in under clause A. by including all vegetation within the natural forest, such as grassland, thickets, and shrub and understory. Currently, in terms of the definition, the Act define natural forest as a group of predominantly indigenous trees whose crowns are largely contiguous. So the bill is intending to broaden the definition so it can include all type of vegetation within the natural forest, such as grassland and understory. Still under the definition under section 2, the bill is intending to simplify and broaden the definition in order to cater for situations where woodland may be degraded. For example, in terms of the proposed amendment, it's intending to simplify the definition of a woodland. Currently, the Principal Act defines woodland as a group of indigenous trees which are not a natural forest but whose crown cover more than. But the proposal is that it must cover at least 5% of the area they occupy. The bill is also intending to provide to clarify where the national forest resources are to be managed, which is at the national level, by introducing the definition of public trusteeship of the nation forest resources. In terms of clause 3, the bill is amending section 7(1) of the Principal Act by the intention is to broaden the provision under section 7 to include all vegetation within the natural forest, grassland, thickets, and shrubs. Still under clause 3, the bill is intending to amend section 7 by inserting of subsection 5 in order to provide for directive to rectify damage by the minister in the case of non-compliance with the provisions of section 7 dealing with the prohibition and the destruction of natural forests. Clause 3, it's a continuation, it's an amendment of section 7 by insertion of subsection 6 in order to provide for steps to be taken in the case of non-compliance with the directive issued in terms of section 7(5) of this amendment. Clause 4, it's intending to amend section 8 by insertion of new subsection 3 in order to prohibit any activity in a protected area so that the purpose of protected area is not defeated. Clause 5 is an amendment of section 14. Section 14 deals with the emergency procedure for protecting trees. The bill is intending to provide the minister with powers to stop or terminate any activity such as cutting of trees that may need to be protected while still conducting the investigation. Clause 6 is an amendment of section 15(3). Section 15 deals with protected trees. The bill is intending to minimize cost for compliance promotion incurred annually through the publication of the list of protected species. So the proposal, because currently the list is published annually in the government gazette, newspapers and radios, the proposal is to publish the list at least every 5 years or publish when there is change that has been effected to the list. Clause 7 is an amendment of section 17 by insertion of subsection 13. Section 17 deals with control forest area. The bill is intending to provide the minister with emergency power to declare a control forest area in order to prevent continued deforestation. For example, we find that most of the time the forest is deforested prior to declaration due to the process being lengthy. Still a continuation of amendment of section 17 by insertion of subsection 14. in order to provide the minister with powers to issue a directive in the case of non-compliance. Clause 9 is an amendment of Section 23 by inserting new subsection 4 with the aim to prohibit mining activities in a state forest in order to promote effective sustainable forest management. Clause 10 it's an insertion of new subsection 2J for the inclusion of youth and women in the National Forestry Advisory Council. This is the council that advises the minister on any matter related to forestry. The proposal is to include youth and women in this council. Clause 11 is amendment of Section 35(4), still under the National Forest Advisory Council, in order to address the issue of remunerating NFA members when attending council's meetings. Amendment of Section 37(3) is under Clause 12 in order to provide for the extension of the time period that the council needs to advise the minister on issues emanating from the council meetings. Currently, the chairperson of the council must provide the minister with advice or information emanating from any meeting within 2 weeks. The proposal is that it should be within a period not exceeding 1 month after the date of the said meeting. Clause 13 is a new insertion of Section 57A to provide for appeal procedures against a decision taken by an officer, licensing officer. Clause 14 is an amendment of Section 58(6) in order to strengthen enforcement specifically for offences committed in relation to major developments such as mining, and also to align it with other environmental legislation. The proposal is to increase the penalties under 5th category offence from 50,000 to a fine not exceeding 10 million for a period, or imprisonment for a period up to 10 years, or both fine and such imprisonment. Lastly, Chairperson, honorable members and members of the public, Clause 15, it's an amendment of Section 65. In terms of Section 65, the Director General may appoint, designate post in the department or in any provincial administration or local authority whose incumbents are forest officers, and appoint any other suitable qualified person as forest officer. So the proposal is to bring C and D, that the Director General may also determine different levels of forest officers and determine qualification criteria for forest officers. This is to strengthen enforcement and to provide for the grading of these forest officers. And in terms of the what are the implications of this bill, the mandate of the National Forest Act is listed under Schedule 4 of the Constitution. This caused the bill to be tagged as Section 76 in terms of the Constitution, as I've already indicated. Therefore, the proposed amendments are aiming to strengthen the provisions for promoting sustainable forest management and not to change the current administrative processes of the functional area listed in Schedule 4. The proposed amendment will therefore not affect the current provincial mandate with regards to management of forest, and the Principal Act, as I've already indicated, provide various mechanisms to promote the use and protection of forest for the benefit of all. These have not been affected by this proposed amendment. Thank you, Chairperson, honorable members and members of the public for listening to my presentation. That's all from my side.
Chairperson, you might be on mute.
Chairperson Asubuzo, is the chairperson still connected?
Hello, there is no sound for now. I don't know what's happening, but we had sound for a few.
Yep, no sound.
morning. Once again, I was kicked out by the system. I'm not sure why. It just went off. But I am back. I'm not sure how far did we go. Honorable members, I am back. I was kicked out by the system. How far did we go with the meeting? Or where are we?
We were somewhere.
Yes, I was kicked out too.
You finalized the clause, and then after finalizing the clause, thank you.
I can't hear you.
We love.
Everything you asked. How far did we go? Are we done with the presentation? Have we completed the presentation? Can we
Yes,
take
Chairperson.
questions?
Yeah, done.
Okay. So can I take questions and comments from the stakeholders? My sincere apologies as I was kicked out by the system. Let me take this opportunity and allow stakeholders to make submissions or ask questions where there is such. Ngithatha leli thuba ke nginikezela wonke umuntu okhona emhlanganweni ofuna ukubuza umbuzo ofuna ukwenza ukuphawula ngalomthetho esikhuluma ngawo.
Okay, Chairperson.
Anyone is ready to start?
I have few questions for you, Chairperson.
I can't
Chairperson.
hear you clearly.
Okay, I have few questions for you, Chairperson. You're talking to Colin Mabula, member of THO Traditional Healers Organization, Ms. Chairperson.
Okay, you can ask your questions, Bob.
Ms. Chairperson, you were talking about clause again. In this clause, you mentioned about protecting our environment as a whole. Eh? So do you have people or policing who are policing this forest by now? Ms. Chairperson?
Okay. We got your question in terms of the policing of the forest, meaning who's enforcing the bylaws?
Yeah, and what the criteria are you using to hire those people? These people are people who are knowledgeable when it comes to NKS, or they just normal people, any other people can do it.
Okay, one, who's doing the protection of the forest, and two, what is the criteria for those who are hired to do such a work? Do they have capacity? Do they have experience?
Yes, yes.
Okay, those are the two questions. May I get any other questions? Anyone with a question or comment? Okay, may we ask the department to respond to the two questions?
Okay, thank you, Chairperson, honorable members. I will answer the question for policing the forest. Yes, as a department, we do have forest officers appointed in terms of Section 65 of the Principal Act. In terms of this appointment, the Director General may appoint any other suitable qualified person as a forest officers in order to ensure enforcement of this forest. So these forest officers, they have got powers to enter, search and seize and arrest. Yes, they do go for training. They attend various training so that they can be able to enforce this piece of legislation. I will also give an opportunity my colleague Cyril and Pumeza to add the other question. I couldn't hear I couldn't get the second question, so I will give this opportunity to my colleagues to add.
Okay, let's allow them to add then.
Thanks, Chair. Yeah, my colleague is correct to say that we do have officials who are trained. One of the requirements of the Act is that they need to be appointed officially and they need to undergo a certain course. So over a period of time, there are a number of officials who have been trained. The requisite in terms of qualification, the officials that we have so far appointed are foresters. In other words, they are qualified foresters who have got knowledge of forestry. That is your university or college diplomas and degrees. But the requirements do not necessarily preclude people with other qualifications. It could be any other person without they call them RQ qualification, recognized qualification. So we can extend. In fact, we can even appoint people without degrees and diplomas. But we have not yet done that. But that is something that we are also considering to do. What is necessary is to understand what the Act requires. Thanks.
Thank you very much for that response. Any other comments or submission on the bill or questions?
Okay, Honorable Chair. And then what is the, when you catch somebody doing something wrong, what is the fine, or what is what you going to do after it? What is done to a person?
Okay, that's a follow-up question. If somebody is fined there, what is the fine? Are the person arrested? What is the norm?
Thank you, Chairperson. The department provide various measures to ensure enforcement. It can be negotiation depending on the minor or negotiation for minor offenses and first-time offenders. We can also issue a person a warning. We can also give a person admission of guilt fine or spot fine. It depends on the nature of the contravention. The fine will depend on that. Lastly, the last measure that can be taken is a prosecution, which is a last resort. Thank you, Chairperson.
Okay, thank you very much then. If there's no other submission on this bill, I'm counting 1, 2.
Thobela
Rosanna.
wa bolela mo ke go ka Francina from Mamelodi Lusaka. Ke no gopela go check something. Ga go nna le ba ba tlong go re fa molao as traditional healers ja a go nana re kira jwa di khare tsa rena ge ke re ke lebeletse ke bona o ka re bongaka ba rena ga bo promotiwe ba re a gatelela cause le batho ba ba yang go checka dilo tseo I think no ka mo answereng e fileng go Colin aka go ka re go na le a traditional healer o e leng gore maybe o tla form a part gobane as dingaka re a tseba gore nana di khare tsa rena re santse gore na re di kgeya gore re ska ra di bolaya re a tseba gore santse re di protect jwang gore di ska tsa akwa so re gopela gore a melao ya rena ge ba e bea maelana le dikhare tsa rena ba tsebe go ditlhare tše ke ditlhare tše e leng gore ke kgale ntše re bereka ka tšona, and then o ka se re o nyaka go bereka ka setlhare kore wa se epa mo e leng gore ka osane a se sa tlo mela. Se nka se kgopelang ke gore ge re beela molao a gore go bao ba yang go monitora gore re epa jwang, re šireletša jwang, ba bang ba dingaka le bona ba be gona, go bontšhiwe gore re a berekišana ga re berekišiwe. Ke a leboga.
Re a leboga gogo, ke utlwa hantle ngwaneso, but ke kopa re etse a submission, because at the moment ha e bue ka role ya dingaka o ke nnete ntho e bolelang. At the moment department e bua fela ka gore ba tlo di protector bjang di forest, a ba so bue ka go epa bjanong, ba bua ka go di protector fela gore molao o tlo re ha ba thotse motho a epang ba be ba mo fine. Mara ke kopa rona re le di-traditional healers re di dinyaka re etse submission ko department, re ka ra use yona this opportunity ya yona bill e, re ngwale rona re di dingaka re kopa gore in each maybe forest, ke ka tla etsa example, if mo South Africa go na le di-forest tse 10, re kopa in each forest go bane le batho ba emelang dingaka tse 2 ba tlo kgona go bona ba monitore. So ha re ka etsa that submission, then department e tla re bolella gore a ba dumela na ene re tla etsa bjang ntho eo. So ne ke kopa re ngwale go fatshe gogo re submit, re tlo utlwa gore ba re fetola ba reng, because ntho re bonang o ntho re tshong rona bjanong ke gore bona ba e berekela fela ena ba kenye dingaka ka moo, ena ba kenye dingaka gore ba bone le gore meriane e dingaka e di berekisang e di etsa bjang gore di ska fela. So ke kopa re etse submission ngwaneso. Go. In brief, Gogo was saying, I'm not sure if we do have translation, but I've requested Gogo to make a submission. Their submission is that as we are protecting the forest, including the indigenous tree, they feel very strong that they have a role that they can play as traditional healers, because some of the trees, they use them for medicine. And as traditional healers, there is a way that they dig or they cut trees in such a way that that tree will not die in future. And their submission is that if there are those who are enforcing, who are protecting the forest, it is important that traditional healers are also part of that team or are also part of that group, so that they are able to advise and assist the department in terms of monitoring and making sure that the indigenous trees and the indigenous forest is protected and does not die in future. I hope Gogo ngikukhulumele kahle mntane khehla nasengikhuluma ngesilungu. Thembe ukuthi angikhuluma ngamanga. Bengenzela laba baka department ukuthi bakwazi ukuthi wena bowuthini. With that then, honorable members, may we move, if there's no other submission, to the next bill. Singakwazi ukudlula siye kule bill esifuna ngayo.
Okay, thank you, Chair. I'm going to present the National Environmental Laws Amendment Bill. Can everybody hear me?
I can hear you.
Okay, thank you, Chair. The first slide, my colleague is going to project for me because for some reason I have technical challenges today. I'm starting with the acronyms just because the acronyms appear on the slide. DEF means the Department of Environment, Forestry and Fisheries. DMRE.
Hold on for me. The presentation is not flighted. Can you flight the presentation? Because we're still having that one of Environment and Fisheries.
We are Department of Environment, Forestry and Fisheries.
Oh, okay. So you are the one who's making the presentation. Sorry.
Okay,
Okay,
good.
you can continue then.
Okay, the Department of Mineral Resources and Energy is DMRE. The MEC is the member of the Executive Council. NEMLA referred to this specific bill. It's the National Environmental Laws Amendment Bill. NEMA is the National Environmental Management Act. NEMAQUA is the Air Quality Act. NEMBA is the Biodiversity Act. NEM-ICMA is the Integrated Coastal Management Act. NEMPA is the Protected Areas Act, and NEMWA is the Waste Act. CMAs refer to the specific Environmental Management Acts. Next slide. The National Environmental Management Act is the overarching umbrella legislation for the environment in the country. Under this umbrella act, there are specific environmental management acts, and they deal with specific aspects of the environment, namely air, biodiversity, coast, protected areas, and waste in more detail. The National Environmental, and this bill amends all these different pieces of legislation, and that is why it's important to mention it. The National Environmental Management Act is implemented by 11 competent authorities, which is the Department of Environment, Forestry and Fisheries, the 9 provinces, and the Department of Minerals, Department of Mineral Resources and Energy. The National Environmental Laws Amendment Bill was introduced to Parliament in May 2017. The D version of the bill was passed by the National Assembly in November 2018, and the presentation summarizes the D version of the bill. Next slide. There are certain definitions are amended. For example, financial provision, while other definitions are inserted to support substantive provisions, for example, latent environmental impacts, mitigate, rehabilitate, remediate, and residual environmental impacts, while other definitions are added as consequential amendments to support substantive provisions introduced in the bill. For example, municipal council, municipality, and municipal manager. Section 2 of NEMA of the National Environmental Management Act contains principles which applies to all organs of state that may significantly affect the environment. A principle is added, namely that the environment sector must advance and promote the full participation of Black professionals. Section 24 of NEMA deals with environmental authorizations and the instance where environmental authorizations are required. The section set out who the competent authority is under certain circumstances, and it makes provision for environmental management instrument, which either can replace the need for environmental authorization or make it easier for an applicant to obtain one. This section makes provision for prohibitions and restrictions in respect of the issuing of environmental authorizations for certain areas and empowers the minister to make regulations. Next. Clause 3 amends Section 24 to facilitate more flexibility in the use of environmental management instruments. It also provides for conditions and requirements to be included in these instruments. It provides for a publicly available register to be kept of all these adopted environmental management instruments. It makes textual amendments to the prohibitions and restriction provisions to provide clarity, and it clarifies competency of the minister responsible for mineral resources and provide for simultaneous submission of environmental authorization application and any other related licenses or permits required under NDCMAs, as well as integrated processes and decisions where possible. It provides for a requirement that an integrated license must be issued where the competent authority is the same in all instances. Section 24G deals with the rectification and consequences with the commencement of an illegal activity without an environmental authorization. Section 24G, Clause 5 of NEMLA, is amended to enable a person who has taken ownership or control of property, for example, a bona fide purchaser of on which unlawful structure or development has been built, to have such structures, development or activity authorized. It also allowed the successor in title or a person in control of such land to lodge a Section 24 application for such structure or development. Currently, that is not possible in terms of the Act. It makes it mandatory for the Minister or the MEC to take during the consultation process, and then the consultation with state departments are just added. It's currently be done in any event. Amendments to Section 24P deals with the financial provisioning requirement to undertake progressive rehabilitation, decommissioning, closure and post-closure activities to ensure mitigation, remediation and rehabilitation of adverse environmental impacts, and the amendment enabled the Minister and the MEC to prescribe instances when financial provisions is required for activities requiring environmental authorization. The financial provision must be determined before the Minister issues an environmental authorization, and an applicant, a holder of environmental authorization, a holder of an old order right, these concepts are defined in the Act, must provide financial provision for progressive rehabilitation, decommissioning, closure and post-closure activities. The clause stipulates that the rehabilitation, remediation and mitigation measures must be undertaken annual as prescribed. The clause also sets out the financial provision vehicle to be used. An independent party can be appointed if the Minister or the MEC are not satisfied with the determination or review of the financial provision. Respective ministers or MEC may use any part of the financial provision to fund rehabilitation actions if the holder of an environmental authorization, holder of an old order right, fails to do so. The bill inserts a new Section 24PA, provided for, which provides specifically for financial provisioning for mining. This clause requires a holder of an environmental authorization relating to listed or specified activities for or directed related to mining activities, a holder of an old order right, to maintain and retain financial provision until the closure certificate is issued, to review the environmental liability and to adjust the financial provision every 3 years, to independently audit the financial provision and the basis on which it is determined every 3 years, to submit to the Minister responsible for mineral resources the audit report every 5 years, or 3 years in case of a mining permit, and that is just because a mining permit is very short term. To publish the decision of the Minister responsible for mineral resources on the review of the financial provision publicly within 5 days of being notified of such review decision, and to annually undertake measures to mitigate, rehabilitate and remediate. The clause also empowers the Minister responsible for mineral resources, in consultation with the Minister responsible for water affairs, to approve an annual drawdown of the financial provision to support the final decommissioning and closure for the period not exceeding 10 years before the final decommission and closure. Next slide. The clause further requires that financial provision for latent and residual environmental impacts must be transferred to the minister responsible for mineral resources upon issuing of the closure certificate. The clause allows the minister responsible for mineral resources to access the financial provision on issuing of a closure certificate if the financial provision vehicle used is an insurance. The minister responsible for mineral resources or the minister responsible for water affairs is also empowered to use the financial provision to rehabilitate or manage the environmental impacts if a holder of an environmental authorization relating to mining activities fails to mitigate, remediate, or rehabilitate environmental impacts. Next slide. Section 28 deals with the duty of care and the remediation of environmental damage. Clause 12 now empowers the Director General of the Department and the Director Generals of the Department and Department of Mineral Resources and Energy and the head of departments of provinces to issue directives under certain circumstances. The power is now also given in this bill to municipal managers. In line with the Promotion of Administrative Justice Act, the section is amended to allow for a notification and an opportunity to make representation prior to the issuing of a directive. Where remedial measures have been undertaken by the authority due to a failure to comply with the directive, the amendment now empowers them to claim both anticipatory as well as costs already incurred. Next slide. Section 31A up to 31Q deal with the appointment of environmental management inspectors across the 3 spheres of government and environmental mineral resource inspectors in the Department of Mineral Resources and Energy and compliance and enforcement in to do compliance and enforcement in respect of the National Environmental Management Act and the specific Environmental Management Acts. Section 31B, BA, BB, and C are amended to clarify that the ministers responsible for environmental affairs, water affairs, and the MECs are all may only designate environmental management inspectors from organs of state that execute a regulatory function. This is to ensure that only authorities that have the legal mandate to monitor compliance and enforce the provisions of NEMLA and CMAs have designated inspectors within their ranks. The designation by the minister responsible for mineral resources of persons as environmental, mineral, and petroleum inspectors is enabled, as well as the designation of officials from the Petroleum Agency of South Africa to undertake compliance and enforcement activities in respect of petroleum resources. The bill provides for national consistency in the powers and duties accorded to the designated environmental management inspectors, whether undertaking compliance and enforcement with national or provincial legislation. It empowers the minister responsible for environmental affairs, after consultation with the minister responsible for mineral resources, to support or undertake compliance monitoring and enforcement measures if it is necessary to address significant harm to the environment caused by prospecting and mining activities. The same standard of approved training for environmental management inspectors and environmental, mineral, and petroleum inspectors is provided for, as well as the power to prescribe through regulations a code of conduct. Currently, the department do have a code of conduct, but this now make provision, this bill make provision that it can be prescribed through regulations. The powers of these inspectors are also clarified in the bill a member of the South African Police Services has the same powers as these inspectors, except the power to conduct administrative enforcement, for example, to conduct routine inspections, and also the power to issue compliance notices. Next slide. Section 24E of the National Environmental Management Act deals with the treatment of seized live specimens and is amended to provide that live specimens may instead of must be disposed of with a suitable institution, a rescue center or facility, as the circumstances require, or may be disposed of in terms of Section 30A of the Criminal Procedure Act, which deals with mechanisms regulating the disposal of seized perishable items. The regulatory power of the Minister responsible for environmental affairs to specify offences and prescribe the amount for purposes of admission of guilt fines is amended to ensure the Minister's regulatory powers contextualize Section 57.5 of the Criminal Procedure Act. The bill clarifies that a minister or the Minister of Mineral Resources may delegate his or her powers under the National Environmental Management Act to an organ of state, and she may subdelegate these powers or withdraw such delegation, and empowers the minister responsible for water affairs and municipal manager of a municipality to delegate his or her powers under NEMLA to an official in the department responsible of water affairs or the municipality, respectively. Next slide. Clause 34 amends Clause 43 of the National Environmental Management Act, which deals with appeals against decisions taken under delegated authority in terms of the National Environmental Management Act or the specific Environmental Management Act. The bill allows appeals against a decision taken by Air Quality Act licensing authority, and where the licensing authority is the municipality, the appeal is to the municipal council. The bill clarifies that an appeal will not automatically suspend Section 2484 directive, or at a moment Section 48 states that in the case of appeal, it automatically suspends the decision. But the bill clarifies that that an appeal will not automatically suspend a Section 28.4 directive or any other administrative enforcement notice that is aimed at addressing significant harm to the environment, unless there is good cause shown to the satisfaction of the minister, and the person may also appeal a Section 28.4 directive issued by a delegated official. The bill clarifies offences and penalties, substitutes the criminal offence of failing to comply with the request with an instruction from an environmental management inspector or an environmental mineral or petroleum inspector, and introduces new offences and associated penalties. Next slide. Section 48(1)(a) and (c) prohibit commercial prospecting, mining, exploration, production, or related activities in a national park, special nature reserve, or a nature reserve. Section 48(1)(b) allows for commercial mining in a protected environment, provided that the minister issues written permission. Currently, the clause is amended to the clause amends subsection 4 to provide for criteria under which the written permission contemplated in subsection B may be issued by the minister, The Minister may require any further information that he or she may deem necessary before making a decision. Currently, Section 57 of the Protected Areas Act only allows for the Chief Executive Officer of the South African National Parks Board to be on the board. However, in terms of King 3, the bill now requires the Chief Financial Officer should also be on the board. The amendment to Section 57 is intended to provide clarity that the Chief Financial Officer must be a member of the board. Section 48A of the Protected Areas Act restricts certain activities in marine protected areas. However, Section 89 of the Protected Areas Act, which provides for offences and penalties, does not make it an offence where a person undertakes a restricted activity in contravention with the Protected Areas Act. The clause amends Section 89 to insert Section 89(1)(e) and 2A, and thus creating an offence for any person that undertakes a restricted activity in contravention with the Protected Areas Act. The clause also rectifies incorrect references to offences within the Protected Areas Act. Next slide. The bill extends the scope of the objects of the Biodiversity Act to clarify that, that the object is to provide that the use of indigenous biological resources is ecologically sustainable, including taking into account the well-being of any faunal biological resources. The bill empowers the Minister to prohibit, by notice in the Gazette, any activity that may negatively impact on the well-being of faunal biological resources. Such prohibition will be subject to the normal consultation provisions in the Act, and it must also be done by notice in the Gazette. The power to make regulations is extended to provide the Minister to make regulations in relation to the well-being of faunal biological resources. This is just to make provision for some, that the Minister has some powers to regulate welfare aspects. The intention is not to take over the whole welfare mandate, but just to provide the Minister with some powers in this regard. The bill amends NEMLA Section 3, which empowers, which provides for the state trusteeship of biological diversity in terms of the of common law, biological diversity. In terms of the common law, all wild animals are regarded as res nullius, meaning it belongs to everybody but belongs to nobody in particular. The implication of this common law principle is that once a wild animal escaped from land on which it occurred, the owner of such land loses ownership of the wild animal that escaped. The Game Theft Act 1991 changed the common law status of wild animals in that it makes provision for a person to retain ownership of wild animals that escape from land that he or she adequately fenced, and in respect of which a certificate of adequate enclosure has been issued by the Premier of the province in which the land is situated. The implication is that where wild animals escape from state-owned land, the state may lose a custodianship of the wild animals, and the amendment provides that the Minister may specify species and circumstances under which the state remains the custodian in such cases. Next slide. Currently, all invasive species are treated the same in the bill, in the Biodiversity Act. The amendment allows the Minister to determine measures suitable for different species. The bill remedies an impractical provision which requires that every landowner or controller to know whether or not they have invasive species on their land. Potentially, most people may have some or other invasive plant in their garden and not know it. However, the more dangerous invasive species should be addressed, and the minister is given the power to prescribe the circumstances in which written notification of invasive species on land must be given to the competent authority. The bill empowers the minister to prescribe measures to control or eradicate listed invasive species. Categorization of species in the regulations is not taken into account. The bill provides clarity that the chief financial officer must be a member of the board of the National Biodiversity Institute, just to align with the other amendment as well. The bill provides clarity that the MEC for Environmental Affairs in each province must follow the consultative process set out in Section 99 and 100 of the Biodiversity Act. Biodiversity Act when exercise the power under the Act. Currently, that is not the case. I'm now going to deal with the amendments to the Equality Act. Section 13 of the Equality Act deals with the establishment of the National Equality Advisory Committee. The bill provides the minister with the discretion to establish the National Equality Advisory Committee. Section 22 of the Equality Act is amended to provide for the consequences of unlawful conducting a listed activity, the same as Section 24G in NEMLA. The clause will address two scenarios, namely to provide for those activities that were operated without a registration certificate under the Atmospheric Pollution Prevention Act, and those activities where there is no atmospheric emission license obtained under the Equality Act. The bill provides for a process and procedures to be followed in addressing the non-compliance with the law, and further empowers the minister to direct an applicant to undertake certain action, including undertaking public participation as prescribed under the Environmental Impact Assessment Regulations. It sets the administrative fine to a maximum of 10 million. The bill clarifies that the provision must be regarded as a licensing authority, that the province must be regarded as a licensing authority where the listed activity falls within the boundaries of more than one metropolitan municipality or more than one district municipality, and indicates the instance where the minister is the licensing authority to issue atmospheric emission licenses for air quality activities. Next slide. The bill intends to facilitate the issuing of integrated environmental authorization where the minister is also the competent authority for the environmental impact assessment activities and licensing authority for waste management activities. The current provision appears to suggest that the minister will always be the licensing authority, whereas the intention is to provide that the minister is only the licensing authority if the minister is also identified as such in terms of NEMA and the Waste Act. The bill enables a cooperative agreement to be reached between the municipality and the MEC and the minister as to who is the licensing authority for a specific application. Currently, NEMA contains such a provision, and this provision is now also introduced in the Equality Act. The bill inserts a new Section 47A to provide the licensing authority with the legal power to revoke or suspend an atmospheric emission license, subject to the legal requirements set out in the section, and also sets out a procedure to be followed before a licensing authority may revoke or suspend such a license. The bill clarifies and ensures that appeal regulations developed under Section 43 of NEMLA are also applicable to the appeals against air quality decisions. Next slide. Section 60 of the Integrated Coastal Management Act has been amended to allow for the issuing of notices for the removal of structures that were erected prior to the commencement of the Act. The amendment clarifies the retrospective effect of Section 60. Currently, retrospectivity is implied, and its application may leave doubt. This is also in line with Section 59 of the Act and Section 28 of NEMLA, which expressly enables retrospective application. Chapter 9 of the Integrated Coastal Management Act, which deals with appeals under this Act. It is the only specific Environmental Management Act, or SEMA, under the umbrella of NEMLA that has its own appeal provisions, despite the fact that the NEMLA appeal provision specifically apply to all SEMAs. To streamline and avoid duplication, the appeal chapter in the Integrated Coastal Management Act is being repealed. Next slide. Amendment to the Waste Act. The bill inserts certain definitions, for example, building and demolition waste, business waste, domestic waste, general waste, hazardous waste, inert waste, that were contained in Schedule 3 of the Waste Act and is now removed from Schedule 3 and inserted in Section 1 of the Act. The bill inserts certain new definitions of residue deposit and residue stockpiles in alignment with NEMLA and the Mineral and Petroleum Resources Development Act. The bill provides for textual amendments to the definitions of waste so as to provide legal clarity on the interpretation and to prevent unintended consequences. The bill provides clarity that residue stockpiles and residue deposits are no longer regulated under the Waste Act, but under NEMLA. Next slide. The bill amends the Waste Act to establish the Waste Management Bureau as a fully fledged entity. It establishes a juristic person with a board, and in the absence of a functional board, the powers and duties of the board revert to the minister responsible for environmental affairs. It also set out the minister's supervisory functions. The rest of the sections 34F, 34G, 34H, 34I, J, K, L of the Waste Act sets out the general powers of the Waste Management Bureau, the governing board of the Waste Management Bureau, the composition and membership, the qualification of members of the governing board, the appointment procedure for members of the governing board, the term of office of the board, and the conditions and appointment of members of the governing board. The bill inserts new section 34M to Z, which sets out the governance matters of the board. The bill provides clarity that an owner of land that is likely to be contaminated has the legal obligation to notify the minister of such contamination as soon as the owner becomes aware thereof, and clarifies that a site assessment report must be submitted together with the remediation plan. The bill indicates that the minister must keep a national register of all contaminated land. Next slide. Section 43 of the Waste Act identifies the licensing authorities for the different waste management licenses. The minister responsible for mineral resources is identified as one of the licensing authorities to issue waste management licenses insofar as the waste management activities is or directly related to prospecting or exploration of a mineral or petroleum resource, or extraction and primary processing of a mineral and petroleum resource. The bill provides that the minister responsible for mineral resources as the identified licensing authority is responsible for the implementation of the waste management licensing system insofar as the waste management activity is or is directly related to prospecting or exploration of a mineral or petroleum resource or extraction or primary processing of a mineral or petroleum resource. The bill facilitates an agreement between the licensing authorities on the implementation of the licensing system. In exceptional circumstances where the MEC unreasonably fail to take a decision to issue waste management license or not within the prescribed timeframes, the bill provides that the applicant may request the minister to take a decision. The department was mindful of Section 125 2B of the Constitution of the Republic of South Africa in 1996, which provides that the Premier, together with the members of the Executive Council, has the power to implement all national legislation within the functional areas listed in Schedule 4 or 5 of the Constitution, except where the Constitution or an Act of Parliament provides otherwise. Currently, the variation of a waste management license is not subject to the payment of a prescribed processing fee. Practically, it has been established that the variation of a waste management license involves a lot of work. Clause 71 provides now for the payment of the prescribed processing fee for the variation of a waste management license. Clause 72 is a consequential amendment deleting the offence regarding residue stockpiles and residue deposit. These stockpiles and deposits are no longer regulated under the Waste Act but under NEMLA. The clause also creates an offence if a person contravenes a provision of a nominal standard. Clause 73 is also a consequential amendment deleting the minister's powers to develop regulations. Residue stockpiles and residue deposits are no longer regulated under the Waste Act but under NEMLA. Next slide. The provisions of Section 74 do not provide the minister responsible for mineral resources with the legal power to issue exemptions, and the amendment is just inserted to allow the minister with the necessary exemption powers. The bill replaces the expression Minister of Water Affairs and Forestry with Minister responsible for water affairs, thus to avoid every time that the designations of the ministers change or the portfolio of the ministers change, then we need to amend the acts as well. Schedule 3 provides for sources of waste and is read with the definition of waste contained in Section 1 of the Act. Clause 81 repeals Schedule 3 in order to provide clarity as to what constitutes waste. The revised definition of waste provides clarity on what is regarded as waste, and the schedule is therefore no longer required. I'm now dealing with the amendment to the National Environmental Management Amendment Act 2008. It appears that there is legal uncertainty whether an environmental management plan or an environmental management program approved and issued in terms of the Mineral and Petroleum Resources Development Act prior to the implementation of the One Environmental System on 8 December 2014 is deemed an environmental authorization under the National Environmental Management Act 1998. The bill amends Clause 12 of the National Environmental Management Amendment Act to provide legal clarity that an environmental management plan or program applied for and approved in terms of the Mineral and Petroleum Resources Development Act 2002 on or before 8 December 2014 is deemed to have been approved and issued in terms of the National Environmental Management Act 1998. The bill provides clarity that if an environmental authorization or a waste management license was required for activities related to mining activities before 8 December 2014 and obtained prior to the commencement of such mining activities, or if an MPRD right or permit was required prior to 8 December 2014 and was obtained prior to the commencement thereof, such environmental authorization, waste management license, or mining activity right and permit is deemed as a fulfillment of the requirement of the National Environmental Management Act and Waste Act. However, if an environmental authorization and waste management license was required but not obtained or refused, this will not be regarded as having fulfilled the necessary requirement. The bill further provides that the minister responsible for mineral resources may direct a mining right permit holder to upgrade the environmental management plan or program if operations are likely to result in unacceptable pollution, ecological degradation, or environmental damage. The bill also enables the minister to issue an environmental authorization once the deficiencies have been rectified. The bill provides for transitional provisions regarding residue stockpiles and residue deposits because of the removal from the Waste Act to NEMLA. It provides for clarity that residue stockpiles and residue deposit approvals or waste management licenses issued in terms of the Waste Act remain valid until they lapse or are replaced under NEMLA. It further provides clarity that the regulations pertaining to the management and control of residue stockpiles and residue deposits developed under the Waste Act remain valid and are regarded as being developed under NEMLA. The bill also provides for transitional provisions for the Waste Management Bureau because there is currently a Waste Management Bureau in NEMLA in place. And clarifies that anything done by the Waste Management Bureau under the repeal Part 7A of the Waste Act remains valid until any subsequent new provisions override it. The bill further indicates that the Waste Management Bureau in place at the time of the commencement of the Amendment Act remains in place until members of the board are appointed in terms of the new Section 34G of the Waste Act. The bill provides further clarifies that a minister may direct that employees or the CEO of the Waste Management Bureau at the time of the coming into effect of the Amendment Act be absorbed in the new structure in their existing positions. Next slide. Thank you, Chair. That is all from me.
Chairperson, can you hear us? I don't know if it's just me. I can't hear anything anymore.
We can't hear either.
Okay, so it's all of us. Let's see. Perhaps the chairperson got kicked out. I'm not quite sure. Let me take a look.
Okay.
And then we can see.
I will propose that, Honorable First Chair, you can continue until the network kicks back with the Honorable Chairperson.
Okay, I can do that. Yeah, until because chairperson is in the meeting. Maybe she's just having some technical difficulty. But thanks to the department for that. Yeah, for clarifying and for taking us through. I'm not quite sure if we want to now hand over back to our stakeholders if there's anything else. I also got kicked out of the meeting around the same time everyone else did. So I'm not quite sure if our stakeholders have been able to engage this particular presentation. If I could be guided by you, Honorable Ngube, if that's where we are.
I think you have to stakeholders to ask questions.
Okay.
And also if they do have some comments, or also if they have written submission, they can also that.
Okay, perfect. Thank you very much. Right, to all of our stakeholders, I think you were able to hear and see the presentation from the department, particularly their NEMA, for the new amendment rather. Can I note hands for those who want to make a comment or ask a question? You also, if you want to put it in the chat box, that's also possible. I see hands are already up. Let me start noting. I see Glenn. I'm seeing NSPCA Admin 2, you're noted. Abisa, you are also noted. Before I hand over, are there any other stakeholders who are unable to put up their hands who would like me to note them? You can just unmute yourself and say your name.
Cebisa Gamabena.
Okay, Abisa, I've noted you already. You are number 3.
Thank you.
Okay, if there are no other stakeholders, I already have the 3 speakers. Let's start with Glenn. Glenn, your hand is up. Go ahead.
Thank you very much.
Yeah, go ahead.
Thank you. Good afternoon. Can you all hear me?
We can hear you.
Okay, excellent. Thank you very much for the presentation by the department. It's appreciated, as well as this opportunity to finally provide some inputs that we have on the National Environmental Management Laws Amendment Bill. We have been in the process of engaging with the department, national department, before the bill went to the
Honorable Chairperson. Honorable Chairperson.
Yes, Member Ngube.
Yeah, can he also indicate the stakeholder that he's coming from? Thank you.
Yes, that's useful. Glenn and anyone else who's going to be speaking, if you could just, when you introduce yourself, say which either organization you come from or what your role is as a stakeholder, just so it's easier for us to understand where you're coming from. Sorry for the interruption, but that is useful for us.
Sure, no problem. We did introduce ourselves at the beginning, but it's Glenn Malherbe, Head of Policy Analysis at the Chemical and Allied Industries Association. So again, thank you very much for this opportunity. We have been engaging with the National Department before the bill actually reached Parliament and the National Assembly. We did struggle to get feedback from the department at that time. We then heard that it had been considered by the National Assembly. That's before the 6th Parliament came into being, and there were a number of portfolio committee amendments at that time that we just concerned haven't really been engaged on since. So we are very grateful for this opportunity. Now that the bill has moved to the National Council of Provinces, we feel this is perhaps our last opportunity to provide these inputs. So I'd like to go into those, just briefly, being cognizant of time. We did submit input to the department during the process, to the national department, and we, however, are mostly concerned with the new portfolio committee amendments that were made in the time of Honourable Mulewa's ministry, and also regarding the definition of waste. So if I could just go through these 4 or 5 points, I'd appreciate that, and we will follow it up with a written submission to the province. So firstly, on the definition of waste, this matter seems to continue to be an issue to stakeholders in terms of interpretation, and we really trust that recent legal outcomes on the definition of waste will be considered by the department, the minister, the National Assembly, and the National Council of Provinces to ensure that the definition of waste is simple, easy to interpret, and takes cognizance of the fact that there is opportunity to beneficiate waste. On the Section 24G amendment, we find that we are really facing a very, very complex environmental legislative environment. It's very complex and it's ever changing, and companies in the private sector are really finding it difficult to keep up really with all the changes. And Section 24G now makes it removes the discretionary power to implement penalties on commencement of activity without an environmental authorization, and we just request that is reconsidered. There are many instances where there are different interpretations by companies of the law, and some cases even different interpretations by the legal fraternity. So these kind of interpretation challenges do need to be provided for in the legislation, and not simply a one size fits all or blanket approach being implemented. Section 24P on financial provisioning. We appreciate the challenges that the mining sector has seen in recent years implementing the legislation that was specific to that sector. With the NEMLA amendment, the minister can then, in certain instances, and that's all the detail that is given in the bill, can request other sectors or activities to have formal financial provisioning. We'd just like to find out how those instances will be considered and what provisions will be included to ensure that there's not over-regulation here, where it can be shown that companies already have provisioned financially for the environment. Section 28 and 43 we can take together in terms of our concern. It is, number one, increasing power of those with the power in terms of compliance notifications, and it's also increasing the power to other persons. As industry, we have seen a number of instances where compliance officers don't necessarily have the requisite skills or experience in the complex chemical industry or waste management industry, for that matter, to understand a specific process sufficiently, and we can actually demonstrate these by example. So what we're really asking for, together with increased skills in the compliance monitoring sector, of which there's separate regulations that were amended some time ago that, compliance officers are capacitated to be able to apply their minds. And this is really important, given that NEMLA is proposing to remove the fact that an appeal stops a compliance enforcement notice. We find this very problematic, as in a number of cases, compliance notices that are issued can be explained to not actually be valid or relevant. And this is a great concern, because if it is not a relevant or correct compliance notice, and there's and the appeal doesn't put a hold on the compliance notice, this can lead to severe economic consequences for the company. Just want to see if there's anything else. Just on the note of the regulations for compliance officers, even although the regulations do stipulate courses that are required, we believe that there is a great deal more capacitation that needs to take place in that sector. With that, those are just my main points from Kaya, and like I said, we will be submitting a formal written submission on the matter, and we thank you finally for this opportunity to provide these concerns for further consideration. Thank you very much.
Thank you, Glenn. And if you can also make sure that you send it on to our portfolio committee as well. I think that will be useful, especially to go through it in writing, cross-check, because I think some of the points you made, we will also have to go and cross-check and just, do a little bit of our research, but we really appreciate that. Chairperson is back in the meeting, so I'll hand over back to her, and then I'll continue just taking notes and listening in. Chairperson?
Thank you very much, Member Hassan, for that. I was kicked out of to change from the tablet to the phone. I'm using my phone now. I think you'll have noted other two hands. Can you allow the next person to speak? Because it was 3 people who were identified to speak. Who's next after Glenn?
Thank you, Chairperson. It is Priscilla Stichting from the NSPCA, if I'm allowed to continue.
Yes, you can continue, Priscilla.
Okay, thank you. So the NSPCA, we're a statutory body established in terms of Section 2 of our Act, the SPCA Act, and that furthermore, Section 3 of our Act legally obligates us to prevent the ill treatment of animals and take cognizance of the application of laws affecting animals and to make representations in connections therewith. And we also have to do everything reasonably necessary in the achievement of these objectives. So the NSPCA is both obligated and empowered to prevent animal cruelty and to promote animal welfare in terms of our statutory mandate. And we also enforce the Animals Protection Act throughout South Africa. So taking that in regard, we will also make a written submission before the due date. I would like to start with the first area of concern, and that is the National Environmental Management Act, the NEMA Act, Section 34E. So the proposed amendment states that they've changed it that for any live specimen that has been seized, that specimen may be taken to a facility for its care. It changed from must to may, and we would like to know what is the objective in that change, because we're concerned that in terms of the fate of an animal, a live animal, prior and after the finalization of a criminal procedure, as it doesn't afford adequate protection to a seized live specimen. It does not definitively provide a framework that ensures that the final decision followed a sequential order that resulted in the best interest of the animal. And then also the final decision over a seized live animal should be consulted or made by the relevant authority in terms of their mandate and duty and functions, like if you're working with a protected species. And then there's also a need to ensure that there are adequate care facilities available for these seized live specimens as a result of confiscations and prosecutions, and that the final decision does result in the best possible outcome in the interest of that individual animal. Even if that involves euthanasia, if that serves to be in the best interest of the animal. So just clarification in terms of what is the code of conduct and how a seized live specimen will be treated, because it leaves it open-ended. That's the one question we have on the NEMLA Act. And then following down to the NEMBA Act, where there's a well-being clause into NEMBA. So the NSPCA, we do welcome the long-last recognition that animal well-being is now going to be included or proposed to be included into NEMBA. However, we would like to know if the definition, the proposed definition for well-being, have they considered the court rulings, two court rulings in terms of recognition to the Section 24 of the Constitution, where it states that everyone has a right to an environment that's not harmful, and where animal welfare and conservation were linked. Because at the moment, it's only relevant to the state where the living conditions of a faunal biological resource is conducive to its health. And that serves animals in a very limited manner, because there are so many other factors that influences the well-being of an animal. And we want to know it might need to be revised so that it includes the physical, physiological, and the psychological state of an animal. Because something that's conducive to its health, it's limited, and well-being needs a more comprehensive definition and a comprehensive approach. And then the other area of concern is the application area of the well-being clause, and that it's only applicable in terms of the sustainable use of a faunal biological resource. We feel that it's inadequate in terms of the objectives laid out in Section 2 of NEMBA, as well as we want to know if consideration was given in terms of the two court rulings, both for the NSPCA, where it was stated that in fulfilling the rights contained in Section 24 of the Constitution, the state, through its organs that implement legislation applicable to biodiversity, must manage, conserve, and sustain South Africa's biodiversity and its components and genetic resources, and implement the NEMBA Act to achieve the progressive realization of those rights. So the argument is made that why is animal well-being only being considered in terms of the use of an animal or biological resource, and not to the Section 2 and Section 3 of NEMBA Act. And then lastly, the only other question that we have is, why is exotic animals in South Africa being excluded from the well-being clause, as animal welfare doesn't discriminate between species? Thank you. That's all from my side.
Thank you very much. I think they will respond from the department. Can we get the next one, which is the last speaker?
Ngiyabonga mgcini sihlalo. Igama lami uCebisa Gamabhena. I'm a traditional medicine practitioner like Mamelodi. I'm from the organization called Mutung African Heritage. Our project is right on top of Magaliesberg Mountain in Mamelodi. And mgcini sihlalo, ngibanewari bengifuna just ezinye izinto ngithola clarity about enye presenter iye yakhuluma ngade black professionals. Clarity ukuthi, when you talk about the black professionals, are you including indigenous knowledge holders? Because in their own right, they are professionals and they are caretakers the environment. And another thing engithanda ukuthola clarity ngayo, enye presenter ibonisile ukuthi kuba ne-funding for rehabilitation yendawo ezithize ezifana namahlathi and so forth. But who's supposed to look after that? How much and how far does the local governance plays an important role, especially in this funding? Because I'm talking from the experience in terms of the piece of the mountains I'm in, is that it's a dumping site. And I'm worried if we're going to funding for local governance or rehabilitate as such, why the strip of the Mahalis mountain is still a dumping site in terms of aguna protection, aguna fence, akwenziwa lutho. Awekho ngisho ama-inspectors, because esinye isikhulumile ngama-inspectors and the police service abanama-lungelo nama-powers. It's not true. Maybe logo ku-apply kwezinye indawo, not in the area I'm in, because you knock to the police department talking about the environment, and they will tell you that that is not their what you call their area of what you call specialization. Now, AMA inspectors, when we talk about the inspectors, who kill my inspectors? Because we are having our natural resource in Mamelodi, but it's not taken care of. And I cannot go to any other piece of the Mahalis mountain outside of Mamelodi, an inspector or a police or a metro police who's guarding the area. So I'm really worried that when you talk about black professionals, abomama abatezi inkuni because they lack knowledge. They are professional in their own right, in a sense of they are caretakers of. They know exactly which plants okanye inkuni okanye ihlahla fuze bazikhatha. So ngiyaswaba mina after 26 years siphethe indawo esafana neMagaliesburg mountain ekubantu bethu okuyigugu kithi njengoba sikhuluma ngalezi zinto imithetho it's not taken care of. Where are these? After 26 years kusa-amendwa and angizwa igalelo leyinyanga zesintu zi-accommodate. And now if inyanga yesintu izama ukwenza input kuthiwa faka leso sicelo yenza input ubhale. I've been attending lama meetings wama amendment and surely indigenous knowledge practitioners ungathi akuzwakali nje kahle as accommodate kahle. And we are part and parcel of what you call. We are part and parcel of what you call environment. Irrespective of ukuthi ihlathi noma intaba noma imifula, but we are part and we know how to take, but we need sekudala siba involved. But sifuna igalelo lethu sizibone. Kuma-board ahlalayo, how many indigenous knowledge practitioners ahlalayo kulawo ma-board enza ama-decision amaduna amadonsi? Ngiyabonga mgcini sihlalo.
Siyabonga babucebisa. Ngizocela mina babucebisa ukuthi ukuze ngishilo nakule mhlangano besikuwo ukuthi ukuze sizwakale kahle njengabaholi bama-traditional leaders. Mina ngalendlela engibona ngayo ngibona ngathi inkinga sivele senze i-submission kulo mthetho lo bese iyahamba izoconsiderwa nje mayelana nalomthetho. Isicelo sami nje ngiyacela kakhulu ngiyaphaphatha kuma-traditional healers nakuma-traditional leaders ukuthi ake sisebenzise lento abayibiza nge-petition committee. Ikhona i-petition committee e-national, ikhona i-petition committee ku-province. Kakhulu kule petition ekufuneka siyenze funeka sifake ukuthi sinesikhalo thina njengama-traditional leaders nama-traditional healers ukuthi kuzo zonke uhulumende izinto azenzayo ngathi iqhaza lethu alibonakali okanye indima esiyidlalayo ayibonakali. Because ngicabanga ukuthi funeka ilungiseke kwalapho nje ekutheni singayibambi kumthetho omncane, sibambe nje kuye uhulumende nje wonkana ukuthi ake kube nembizo, imbizo yama-traditional healers nama-traditional leaders. Uhulumende akazochaza because ngikuzwe kahle ukhuluma ngokuthi nakuthiwa ukukhuluma ngama-black professionals, nibekwaphi nina? Cishe ngathi ngolwazi lwami oluncane anikho lapho nakhulunywa ngama-black professionals. Yile nto kufuneka siyilungise le engicela kakhulu ukuthi make kube nesigungu la kuhlalwa khona kubizwe nje imbizo ukuthi ake kuhlalwe nama-traditional healers nama-traditional leaders ke kulungiswe isimo sawo. Ngizokwenzela umzekelo omncane futhi ekuwomunye esibuya kuwo bekuyinkinga bengihlangabezana naso. Njengoba besiku-lockdown bekunenkinga ukuthi abodokotela yilaba abababiza ngama-professional bona. Abodokotela bebavumelekile ukusebenza bavula ama-surgery wabo okanye iminyango yabo yokusebenza. Izinyanga nabalaphi base-South Africa bebangavumelekanga. Angazi noma uyabona nabakucebisa la ngiyakhona. Izinyanga bezingavumelekanga ukusebenza. Nalabo bebasebenza ngokwenqa umthetho. So ngicabanga ukuthi kuyinkinga kwakona lokho nje kokuqala ukuthi bakhulunywa ngabodokotela eSouth Africa. Izinyanga azibalwa njengabodokotela. Izinyanga akubalwa ukuthi zona umsebenzi wazo uyini. So ngaloko ke yiko ngicela ngiyaphaphatha. Angazi noma isikhathi sizongivumela na nekomiti izongivumela na nedepartment ukuthi kwathina nje la eGauteng njengoba ngusihlalo. Ngelinye ilanga kufuneka sibe nale mbizo yokuxoxa nje ngomsebenzi wethu, irole yethu, uhulumende uthini nakakhuluma ngathi uthi singabobani, simsiza ngani, usisiza ngani. Okwesibili okunye kuye kwavela futhi kulo mhlangano besikuwo babucebisa ukuthi ugovernment ukhuluma ngama-grant relief lazo siza khona amabhizinisi amancane aye ahlukumezeka ngendaba ye-COVID-19. Kodwa nalapho nawuthi uyabheka futhi izinyanga nabalaphi ababalwanga lapho ngoba bona baregisteranga bangama-informal traders. So kakhulu nangathi uyabheka kule 26 years okhuluma ngayo kuyiqiniso ukuthi ama-traditional healers nama-traditional leaders asengekabhekeleki. Mara ngiyacela ukuthi into ekufuneka siyibhekele senze i-petition. May I take this opportunity and allow the department to respond to some of the questions raised by the stakeholders?
Thank you, Chair. I have, in relation to the questions by Mr. Malherbe, the definition of waste, we definitely, maybe not at the time of the drafting of the waste definition or when it was considered by the National Assembly, but we definitely take into consideration the court judgment in that case. I note in terms of Section 24G and the compliance officers, I'm going to ask Ms. Riedlinghuis to respond to those questions in respect of the compliance officers. Most of his comments are basically for noting, and we await his written response, but she can respond to some of them. In relation to questions of the NSPCA, I will ask Ms. Martel Boshoff to respond to that, and also the question in relation to the well-being. Section 24P, how will this be considered for other? We haven't applied it yet, but I will give Dr. Lee Fisher an opportunity to respond to the question on Section 24P. If for other matters, how will it in those instances consider for which activities would a financial provision apply for? In relation to the black professionals, and these are the my colleague translated for me, where are environmental inspectors in places like Magalies or Mamelodi? Magalies Mountain is not looked after or protected. The voice is not heard to be as part of traditional healers while they are part of the process, and they must be recognized as the custodian of indigenous knowledge in places like boards. And then the government must clarify the role of traditional leaders. The support of traditional leaders are not catered for in COVID-19, etc. We will definitely consider these comments. I haven't given it much thought. The principle in relation to the incorporation of the Black professionals in the environmental sector was more aimed at, for example, the environmental practice assessment practitioners, which is currently involved in the and also scientists that we used in terms of our environmental impact assessment process and in terms of the other CMAs, more to promote their participation and in these processes. But we will definitely consider the role of the traditional healer. I have not given much thought to that. I will ask Dr. D. Fisher to respond a bit more on that principle itself and its application in terms of NEMLA and maybe the CMAs. Okay, we can start with the compliance, maybe on the compliance officers.
Okay, thank you, Linda. Thank you, Honourable Chair and Honourable Members and stakeholders. Specifically, Mr. Malarbe, thank you very much for your questions. All of them are noted. Specifically with regards to Section 24G, when we, in the current Act, if the Minister or the MEC has a discretion to direct the applicant to immediately cease the activity pending a decision on the application, in effect, we are actually allowing an illegal activity to continue. And that is why the amendment is made that takes away the discretion of the Minister or the MEC to decide whether or not to direct the applicant to cease with an activity. But remember, there's always the clause in there that's also in the amendment bill, which says that the Minister or MEC must direct an applicant to immediately cease the activity, but there is an exception unless there are reasonable grounds for believing that the cessation will result in serious harm to the environment. So there's always that, I don't want to call it a backdoor, but that exception which allows for an activity to continue. So if you are directed to immediately cease, there's always that opportunity to discuss this with the competent authority and to see whether there are reasonable grounds to believe that cessation will result in serious harm to the environment.
Thank you very much. Is that all in terms of the responses?
The next person is Dr. D. Fisher.
Okay, Dr.
Thank you, Chair. Thank you, Linda. Thank you, Honourable Chair. Thank you, Honourable Members and members of the public. I'm going to answer the question on the 24P. The question was asked, what will the procedure be for identifying other activities that would require financial provisioning? And I think the concern there is, it was stated that there would be over-regulation. In order for the only activity that has been identified to date for financial provisioning is mining, and that has come from the pre MPRDA Mineral and Petroleum Resources Bill, so around about 1991. In order for other activities to be identified, they will be prescribed in law. So the Minister will have to identify which activities would be identified in a gazette, and there would be public consultation on that. So there would be opportunity for any member of the public to comment on that and to ensure that there is actual need and reason for including that financial provision. I'm going to also then at the same time just take a question on the Black professionals. I think Advocate Garlip did indicate that the Black professionals were intended for the work that was carried out in terms of the EIA and the CMAs, so there hasn't been much. There wasn't. It wasn't included in terms of traditional healers. But I think, as Advocate Garlip said, we would actually have a look at that and see how we can include. Making sure that people with traditional knowledge are included as in the definition of Black professionals. Thank you, Chair. Thank you for the opportunity.
Thank you very much. May I check, is there any other person who wants to make a comment before
Martel?
we close the meeting? Martel?
Good afternoon, Honourable Chair, Honourable Members, stakeholders and colleagues. Thank you very much. Yes, I will be responding to the questions of the NSPCA that were directed about the well-being clause in the Biodiversity Act, which have been included there. There's three aspects that I just shortly want to respond to. The first one relates to the definition for well-being and the concern that the definition may seem to be too broad and open-ended. We intentionally provided a broad definition that refers to the health of the fauna biological resource, which basically just means it's an animal resource. Because our experience is when we try to make something too specific and too much detail, we run into trouble that we have unintentionally excluded something that should have been included. So if we refer to the health of a wild animal, we don't intend to exclude psychological or physiological aspects, and we don't intend to refer necessarily only to the physical or health of the animal. So it's not exclusive of other aspects of the health of the wild animal. Then the second part was whether the department will be considering the court rulings, the two court rulings related to well-being, welfare of wild animals. I just want to repeat what Advocate Garlip indicated when she made the presentation, that the intention with the inclusion of these provisions in the Biodiversity Act is not intended to take over the main mandate of welfare, which is vested in the Animals Protection Act and the Performing Animals Protection Act, and that lies with the administration of the department responsible for agriculture. However, there is a gap in the legislation at the moment that we try to address, and that is where wild animals are kept in captive environments. Currently, there are no legally binding standards or mechanisms or measures to hold the owners of those animals to a certain standard to prevent the ill treatment of those animals in captive facilities. So we want to address that gap. And yes, when we develop those provisions subsequent to the implementation of the enabling provisions, for example, if the minister prohibits certain activities or she makes recommendations or she develops norms and standards, we have to consider those judgments, and we have to consider what the implications are to know the extent to which we can or must develop those subsequent provisions. So yes, we will be bound both by those court judgments. And then also the last one is why the provisions are excluding exotic animals and why are they not included in the provisions for well-being. And there I just want to highlight that it may seem that it's excluded from the welfare provision if one considers Section 2 of NEMLA, where that section is amended. Now, Section 2 is about the objectives of NEMLA, and generally NEMLA focuses on the protection of indigenous biological resources and not at the protection of exotic biological resources. So in Section 2, where we refer to the well-being, it's referred to in the context of indigenous biological resources. But if one look at the enabling provisions in the rest of the bill, for the minister to make regulations or the minister to prohibit activities. There, the provisions refer to faunal biological resources or an animal resource. It's not specifically focusing or directed only to indigenous biological resources. So if there are exotic animals in captive facilities, the regulations or the prohibitions or the standards that the minister may develop can also apply to non-indigenous animals. So there's no intention to specifically exclude exotic animals from the development of measures to deal with the well-being aspect. Thanks, Chair. I hope I've responded to the questions on the well-being part from my side.
Thank you very much for that responses. Wants to make addition? Linda, you want to say something?
Chair, if you can hear me, the question on section 34E and the reason for its amendment, I thought that it was responded to, but I'm just going to Ms. Riedlinghuis whether she can just respond to that question specifically.
Thank you, Linda. Thank you, Chair, honourable members and stakeholders. So currently, Section 34E makes it mandatory for EMIs to deposit seized live specimens with a suitable institutional rescue facility or centre who is able to willing to house it and care for it. However, EMIs are often not able to comply with this provision due to the lack of appropriate holding facilities, and it may not be practically possible. Circumstances may require that the seized live animal should be quarantined, released back into the wild, euthanized or destroyed or sold. And the current Section 34 gives the EMIs that discretion to, do something else with the animal other than deposit it in a suitable institution, rescue facility, or other centre. So basically, the amendment provides for the EMI the discretion to deposit the seized live specimen, and that makes it open for EMIs to other options, such as circumstances where the seized live animal must be quarantined, released back into the wild, euthanized or destroyed or sold. In addition, we refer and we cross-reference to Section 30A of the Criminal Procedure Act that will provide the EMI with greater flexibility to deal with the seized item according to the circumstances of each case. Yeah, thank you.
Thank you, Chair. That is all from our side.
Thank you very much for the responses. May I check from the stakeholders, is there anyone that we are leaving behind? Ukhona mhlambe umuntu esimvalela ngaphandle ongekaphenduleki okanye osafuna ukuphawula kulomthetho before sivala? Okay, before I close, I'm going to allow the provincial department just to put it on record. What is your view on the both bills? As we did in the last session, you'll just zoom into your last two slides on the view of the provincial department on the two bills. Who's going to do that from the province?
Chair, it will be me.
It's going to be XTN.
Thank you very much then. Can you do that for us? If possible, please fly to your slides.
Thank you, Chair.
Is it showing, Chair?
Not yet. Yeah, it is showing now.
Thank you, Chair.
Thank you, Mr. Munyane. Thank you, Chair. Good afternoon, Honourable Chair, Honourable Members, Honourable fellow citizens. This will be short. This is the GDART legal unit's view on the proposed amendments with reference to the NEMLA amendment bill. The GDART is generally in support of the proposed amendments. It will eliminate many of the current interpretation issues in the NEMA and the CMAs. The compliance with enforcement of the provisions of the NEMAs and the CMA will be made easier. The NEMA and CMA's alignment with the Constitution will be increased. Alignment in between pieces of environmental legislation will also be increased. It will also offer better protection of South Africa's natural infrastructure, which is often taken for granted and which has been in the past destroyed through development and replaced with inferior man-made infrastructure. Section 24 of the Constitution will be served better. Thank you. That is a summary of the presentation on the NEMLA Amendment Bill. Thank you, Mr. Munyane. Okay, the GDART's summary of the GDART's view on the National Forestry Amendment Bill. As has been mentioned in the presentation by the Department of Environmental Affairs, Forestry and Fisheries, the administration of indigenous forests is listed in Part A of Schedule 4 of the Constitution. The proposed amendments are aiming to strengthen the provisions for promoting sustainable forest management and is therefore supported. The proposed amendments will not affect the current provincial mandate with regards to management of forests. This has also been mentioned in the previous presentation. The NFA already has various mechanisms to promote the sustainable use of forests for the benefit of all. These have not been affected by these proposed amendments. Okay, can we maybe go to the next slide, please, Mr. Munyane? The GDART is generally in support of the proposed amendments. It will also, as with the NEMLA Amendment Bill, eliminate many of the current interpretation issues. Compliance and enforcement will therefore be made easier. The National Forestry Act's alignment of the Constitution and other legislation will be improved. It will also, as is the case with the other amendment bill, offer better protection of South Africa's national infrastructure, and Section 24 of the Constitution will be served better by the adoption of the amendment bill. Thank you, Chair. That's all from my side.
Thank you very much. I gave you the opportunity at the end because I already knew that there is no dissenting view from your side. You are supporting the bills, and therefore we wanted to give the stakeholders that opportunity. So we are done with the public hearings from our side. We are going to convene as a committee to consider and also capture the submissions made by all the stakeholders here, and then we'll send our view or our comments on both bills. We requested that all stakeholders, those who attended and those who could not manage to attend, to make the submissions to the portfolio committee by the 5th of October. Then after the 5th of October, then we'll convene a committee meeting. Siyacela ke kubo bonke abakhona la emhlanganweni abezile nabangezanga, uma ufuna ukuphawula ufuna ufaka umbono wakho kule mithetho emibini ehlongozwayo, cela bese sowuyasithumelela ke umbono wakho okanye lokuphawula ngako kule mithetho. Ilanga lokugcina lokuthi uthumele i5 zaka October. Sithumela ke kuSisinozi, sithumela kuMamlebu, laba bebasibizile ukuthi sibe khona emhlanganweni. okanye kule information ekhona lapho kuposta naku-advert. Ngiyaphinda futhi ngiyacela kubaholi bezendabuko, ngiyacela futhi kubalaphi ngokwezendabuko ukuthi kufuneka sibe nesikhathi la sizokwazi ukuxoxisana khona, sikwazi ukuthi simncede okanye sincedisane naye uhulumende wethu ukuthi sisebenzisana naye kanjani, sithole ithuba lokuthi naye asitshele ukuthi uzosebenzisana nathi kanjani. Ngoba kuyabonakala ukuthi emithethweni eminingi, kakhulu lesikhulume ngayo emibili, iqhaza okanye indlela ekufuneka asebenzisane nayo nama-traditional healers nama-traditional leaders ayicaci kahle, futhi kubonakala ngathi ucindezelo lusasekhona endaweni okanye ebangeni lama-traditional healers. Lebo and Sisinozi, I hope we are noting that going forward in one of the stakeholder engagements, we need to have an engagement with the traditional healers and the traditional leaders in the province, so that we can then assist them to craft their petition to national as to their role and how will they want to be acknowledged and recognized by our government. With that, then, may I check with honorable members present in the public hearing if they want to make a comment at this point in time. Honorable members, I'm giving you this opportunity for your comments. Yes, Member Mncube, you can start.
Ngiyabonga mhlonipheki. Ngiyavumelana nawe ukuthi sibe ne stakeholder which is focused yaba of the traditional healers and traditional leaders. For instance, the question of ukuthi abathandazi or izinyanga zibe ne-room within the hospital was long agreed upon iyadabiwa. So ziningi okumele ukuthi nala e-province zilungiswe because i-constitution iyasivumela ukuthi kungenzeka lokho. So as one of our program, Honorable Chairperson, we then need to focus on this. I remember preparing to that the elections, I also met twice with the Abalaki Bendabuko. They were raising many things in terms of government not recognizing and acknowledging their role, which also the constitution in terms of the provincial, the legislature are also responsible in relation to supporting and allow that space of engagement. Thank you.
Thank you, Lunga Mncube. Lunga Silias, you want to comment?
Chairperson, I also raised my hand. Thank you.
I'm covered. Thank you, Chair.
Okay, Member Makubela.
Thank you very much, Chairperson. And I just wanted to say that we must not be apologetic about incorporating traditional healers into the bill. And this should be a clear message that we send to our representatives in the NCOP, that after our meeting with the stakeholders in Gauteng, it was clear that the bill is not representative of them, and then amendments must be made before it is finalized to ensure that they are part of it, because it must not just be a by-the-way issue. Thank you very much, Chairperson.
Chairperson, can you note me? Member Hassan?
Thank you, Member Makubela. Member Hassan?
Thanks, Chairperson. I'm partially covered by Member Makubela. I agree that in our approach to including our stakeholders, I think we also have to take a very decolonial approach, especially on these two bills, because up to now, I think there's been a lot of gatekeeping to the process. And I think that the inclusion of traditional healers and our people on the ground is fundamentally important. So just to reiterate that, and also to thank our stakeholders. I mean, we're going to go through everything in particular detail, but it was quite useful to hear from our people just how legislation tends to impact them on the ground, both in a positive and a negative way. So for that, I think that's been incredible. Thanks, Chair.
Thank you very much, honorable members, for those comments. And thank you very much to all the stakeholders. Just a reminder that can we please submit by the 5th of October to the committee. Thank you very much to the officials from the national department. And thank you very much to the officials from the provincial department. I just want to emphasize to the provincial department that I hope today will have noted that there is a need for us, the legislature and the department, to have a session with our traditional healers and traditional leaders in the province. So I hope you're noting that, so that when a date is identified, you will make yourself available and make such a presentation to that session, which will be organized at the level of the province, beside the submissions that we're going to make today on these bills. But there is a need for us to have that conversation. Mangithathele lithuba ndibulele ke wonke umuntu osekhaya nokhona apha kule session, kuba njengoba siku-lockdown sisebenzisa ezixhakaxhaka okanye oonoxhaka aba bakhoyo. Kukho abantu abasimamele ku-YouTube, kukho abantu abasimamele ku-Facebook. Siyabulela ke ngokuthi nithathe inxaxheba ke kulo mhlangano. Sinethemba loba nizawukwenza ke impawu zenu nizithumele ekomitini. Let me also ngibulele aba bakhoyo apha kulo mhlangano nabathe bathetha ke kule meeting. uThixo anandisele wanga amathongo enu nezinyanya zenu zinganisikelela kukhanye kudede ubumnyama kuvela ukukhanya. Let me thank all the support staff who made sure that this session is taking place. Honorable members, thank you very much. The meeting is officially adjourned. Well done, Madam.
Thank you, Honorable.
Thanks, everyone.
Thank you, Chairperson. Can you provide the official email address, please, where these inputs must be sent?
Lebu, you can do that.
Noted, Chair.
Are you going to do that privately to Mr. Glenn, or are you going to do it now?
I'm sending it now, Chair. I'll also email to him.
Are you sending it on the chat?
Yes, Chair.
Okay.
Thank you very much.
Okay. Thank you very much to everyone. The meeting is adjourned.